Good afternoon, everyone. This is Larry Watson from Upchurch Watson White Max Mediation Group. We are joining today with good folks from Miles Mediation and Arbitration to sponsor today's webinar, Organizing and Structuring Multi-Party, Multi-Issue Complex Mediations. Our panel today are all full-time mediators, full-time ADR professionals. But uniquely, we all come with a great deal of trial court experience. Brenda Newman, a partner here at Upchurch Watson, was a select trial lawyer with the Construction Defect Division of Nationwide Insurance Company after spending about 30 years in the trial courts in Central Florida. John Mills, founder of CEO of Miles Mediation, decades in court as a defense lawyer. Joe Murphey is a principal at Miles Mediation. He's been admitted to every court in Georgia, Superior Court, Trial Court, Court of Appeals, Georgia Supreme Court. So we can bring to this program a perspective of someone who's sort of been on both sides of this, is both the mediation and the trial lawyer involved in the mediation. Our program theme, again, planning and executing the mediation of complex, multi-party, multi-issue disputes. The format of the program is going to be that we were going to set up a model case, sort of lay out a typical complex litigation dispute, and then sort of walk through the ways we might organize and structure a mediation of that case. Our example is going to be a construction case. Construction lawsuits are more often than not multi-party, multi-issue, and they can be quite complex. And it's an ideal base for illustrating methods of setting up the mediation. Our model case, therefore, may involve some construction industry buzzwords, but we want to focus on the process as we identify the typical parties we see in these claims, the typical issue we see in these claims, and talk about the challenges we face in processing the mediation of these claims. When that model's in place, we're going to go through step-by-step procedures that might be used to organize, structure, and formulate a mediation. I'd point out real quickly that there is no textbook on this material. There's no one right way to do this. Differing methods, different steps, all might work. And we're still trying to define the best way to handle these matters. So with that, let's begin to talk about the Oggy View condominium project, construction defect litigation. At the outset, I would note that while construction cases and cases like this can be complex, that is to say, a case with technical or unique subject matter, specialized factual issues, confusing interrelated transactions, the complexity in and of itself is not a significant problem to mediate. Subject matter complexity is simply a matter of learning nomenclature and grasping the fundamentals. And most good commercial mediators are and need to be quick studies. It's the multi-party, multi-issue part of these lawsuits that present the problems. Multi-party, handling the crowd of people that show up, allotting the time appropriately to meet their individual needs while still keeping the group on task and in line. And multi-issue, understanding the essence of each of the positional debates that are being advanced in the lawsuit, recognizing the interrelationship of those issues, sequencing their resolution, and defining efficient negotiation pathways to attack resolution. It's the number of people, number of issues that present challenge on these sort of cases. And one of the first things we talk about is getting started early. From the trial lawyer's perspective, don't wait until you're a month away from the date the judge says you have to mediate to try to put this together. Get the mediator involved early. Get into the mediator selection process early, well before all the discovery goes, well before the motion practice starts, and then use that mediator to help plan and structure the mediation process. For mediators, we have case intake procedures in place and recommend to all of you that will send a trigger out when multi-party cases get booked or come knocking on the office door. An alert goes to the mediator involved that this is not going to be a normal engagement. Initiate, and that's a signal to initiate immediate telephone contact with counsel. If I get a signal, we've got one coming in, it looks like there's 10 parties or less, I'm going to make a point of trying to call each one of the 10 parties. More than 10, we're going to maybe reach representative players from the claimant group, the defense group, the third party defendant group. And there are two objectives to early conduct and getting the mediator in. Number one, I think it's important that the structuring and formatting of the mediation be in the hands of an independent to give the mediator control in organizing, scheduling, and formatting of the mediation. Lawyers are advocates, and they're going to tend to shade things to their advantage. Sometimes lawyers don't do well in talking with each other, and that tends to delay the process and stall things from commencing. And I found that lawyers and staff are usually delighted to have the mediator take over scheduling and dealing with all the interaction stuff to set up the logistics. So getting control of the process is important reason to get an early start, to get involved quickly. And the other point is, I start every phone call off by tell me a little bit about this case. Start collecting essential data that you're going to need to formulate the mediation. What do we ask about? I'd like to start by every complex business dispute you get. There was a way the deal was supposed to look, and there was the way we started all this, the undertaking, and what were the contractual relationships, what were the business relationships that were intended by the parties to get the program underway. Under our Oggy View condo project, for example, this slide meant to show you the kind of chart we prepare to show the contractual layout of what the project was supposed to look at. You got Slick Deal Development there as the owner of the project. He has a direct contract with No Wrong Builders, the prime contractor, and a direct contract with Almost Right, the architect, for the construction and design of the facility. No Wrong Builders then has his subcontracts going down with site work, structural steel, glazing, sealants, cladding, and so forth. The architect's got his consulting agreements with civil engineering, structural engineering. We also kind of track where the insurance carriers are, the CGL policies, just where they're located and who's got them. And so you want to put together the first step, just what would the deal supposed to look like? And then you can branch into looking at, okay, what are the claims and the issues that have popped up? I don't want to resolve the claims at this point. I just want to understand what they are. Well, turns out the project's late, it's over budget, the building's leaking like a sieve, the cluster bombs start flying around. We've got overall delays happening, damages being incurred, water intrusion everywhere, mold, bad HVAC, air not circulating, condensation settling in, site drainage is bad, balconies, windows, and doors leak. Damages, we've got cost to fix, loss of use, lost sales, rentals, property damage, liquidated damages, and then, of course, there's the defenses that have popped up. What are they saying right back? Not my fault. I'm not going to pay. The owner interference, bad design. We've got damage defenses, enhancement, unreasonable cost to fix, counterclaims coming back. And then, as the slide here indicates, third-party claims, the prime versus the subs, looking for indemnity, breach of contract, construction negligence, the third-party counterclaims coming back up, mismanagement, failure to supervise, lack of coordination, and their unpaid change orders that are in there. You'll hear plenty about the lawsuit. Cross claims will be in. This is the multi-issue part. cross claims between the prime and the designer. You didn't give me constructible plans. You tortiously interfered with my work. You breached your fiduciary duty to monitor and to look after the job. You find the insurance carriers. It's really important to get the insurance out quickly as you're sort of asking about this case. The surety will also have, the surety's going to have issues there. Get them in. The excess carriers are going to have issues there. And in the final analysis, it's, how do these cases look? They're multi-parties. 10, 15 is normal, each kind of with its own support team. Multi-claims going back and forth, spreading liability, real imagined damages. Usually they're 2 to 3 years old when they present themselves for mediation. Major process costs have been incurred, legal fees, expert fees, lost employee time, and so forth. Often major emotional costs are incurred. There are hard feelings, anger, resentment. How bad can it get? Well, one of the worst ones I had was the condo project in Rockaway. 48 active parties named in the lawsuit. And I mean active mediation participants, each one advancing their own claims and defenses. They employed over 100 lawyers. There were 20 plus experts. We did the planning to execute this mediation over about 6 days, on and off, and then it took 14 days of mediation session time to actually get the case to the point where it's settled. So they can get kind of crazy, and that leads me to the next of the charts we want to. We charted the how the transaction was supposed to look. I find it very important to maintain a good 60,000 foot altitude view of the case to sort of chart the shape of the lawsuit. This is an illustration of what that kind of a chart can look like. We have Slick Deal suing No Wrong on the main claim, No Wrong then filing his counterclaim, cross-claim over against the architect in gold and green, and then down in the green column we've got the third-party claims that have been filed by No Wrong against his subs. You notice that one of the subs has filed a declaratory judgment action against his carrier. Another sub has filed a fourth-party claim, and a fifth-party claim have come out of it. But with the preparation of these charts, this is a PowerPoint presentation, so it's kind of limited. I typically use legal sheets taped together in a horizontal format, and just like a family tree, you block out the cases and the claims and so forth that have gone back and forth. They give you, these charts give you kind of an essential view of the structure of the lawsuit. And on the charts, I go ahead and put an identification of the parties, as well as their related carriers, the lawyers, and their contact information. And it's a good then guidebook kind of for the mediation process. You get a phone call, you pull out your chart, you kind of, okay, I see where you are and where you fit into the big picture. So we've charted everything out. We understand what everything's going on. One of the first things we need to get accomplished as the mediator, get your business in order. You got to get your action down before you can deal with their problems. And the principal character there is who's going to be paying the fees and cost. What are the terms of our engagement? It's critical. You will be sent a service list as you get one with 20 or 30 parties on it, whatever. I don't trust the service list. Inevitably, people have dropped out. People have been added. You need to confirm by telephone, in writing, and get an accurate head count on who's still in the lawsuit. And then you got to define and get into an engagement letter with each one of them. If you don't use engagement letters on your regular business, you have to use engagement letters in the multi-party, multi-issue cases. And there's a couple of reasons for that. One is the services you're going to be rendering and the services you're going to be billing for as a mediator are going to be far broader than the normal routine show up at the mediation session and walk people through to settle or not settle the case. There will be pre-mediation organizational work. There will be hours spent before you ever get to session. There'll be the mediation session, of course, and more often than not, there's going to be post-mediation follow-up work. And the parties need to understand that they're going to see a lot more than just what the session time was. Also, it's critically important. They need to understand they're going to get a bill for total services equally divided among and to be paid by all parties. And sometimes just defining who the parties are that are going to be sharing in it can present some issues. I define participating, I'm going to bill parties listed on the letter or participating in mediation. And participating in the mediation means active involvement in advancing a negotiated position on any aspect of the dispute. One mediator from South Florida likes to say, if they show up at the mediation with a lawyer, they're going to get a bill. Some of the danger areas, though, that we need to look at here: insurance coverage counsel. You have an insured, and the coverage, they've raised coverage issues with his carrier. The carrier showed up at the mediation with the insurance carrier, insurance coverage counsel, and then the insured and defense counsel, and maybe another coverage lawyer for the insured. Is that two parties getting, or is that one party getting it? Those things are we really going to be mediating a coverage dispute as part of this overall big picture? If so, then that needs to be taken into account about who's going to be paying the bills. Distant third and fourth party defendants. You see this a lot with the big cases. You've got a $250 million construction defect case, and there's a fourth party defendant down there that put up a $25,000 set of mailboxes in the condo project, and he's been sued. It doesn't, why he's being sued and how he's going to be there, and why am I paying my fair 1/20th of this bill? Those engagement letters will make it straight and clarify with those folks. Multiple related defendants with one attorney. This is an area that I personally run into problems with, but we have as a developer who not named as a defendant by the Condominium Owners Association. The developer had created a marketing company, a wholly owned subsidiary, to sell the units. They got named as a defendant. The developer had also formed a management company to manage the facility, and they got named as a defendant. But it's one lawyer, it's one pot of money, it's one entity basically. However, unless it gets cleared up early on, there are going to be some of the claimants saying, no, that's three parties. They should get three pieces of the bill, not just one. So get your engagement terms down and get it clear from the beginning. Then we start the actual planning. Meticulous planning will enable everything you do thereafter to appear spontaneous and elegant. And for every minute you spend in organizing and planning, you're earning an hour in time saved down the road. So we're going to start with pre-organizational meetings, pre-mediation organizational meetings. And there's a lot of options you can have about how you set these up. I've done them where I just want to meet with the plaintiffs group for half a day, talk about organizing, structuring the mediation, then go meet with the defense group. Sometimes that can be problematic when you've got 30 defendants named. I've often found in really big cases that we set up a mediation steering committee to handle the planning and the organizing and the structure of the mediation. One member from the plaintiffs group, one member from the defense group, one member from the third party defendants group. You can bring in people with the biggest claims, people with the most time involved in the process. Sometimes just put a steering committee together with the control guys, the ones that are seeming to be controlling it. But you've reduced the group that's planning the mediation down to 3 to 5 players instead of 35 players. In doing that, you're inviting everybody to attend the meetings. You're sending out a notice of what the agenda will be. You're inviting people to comment on the agenda, and then you're sending out what the decisions were. And as you start about the planning. At this point, Brenda, let me pass it over to you and talk a little bit about the session agenda, the schedule, and what these steering committee or planning committee ought to be looking at.
Thank you, Larry, and good afternoon, everyone. I appreciate everybody spending the time with us this Friday afternoon. I'm going to talk, as Larry said, about the Mediation Steering Committee. The reason we have a Mediation Steering Committee is because you can't logistically put, as Larry indicated, 20 to 30 trial lawyers together at one time and in one place. And even if you could get 20 to 30 trial lawyers together in one time in one place, you usually can't get a consensus from that many trial lawyers. So it's important to get a group of the, I call them the biggest players together, representative from the plaintiff side, the defense side, the third party side, and to create a steering committee. And you combine these players, these big players, which will be chaired by the mediator. So, for example, in the Oggy View example that we're using here today, that Larry just spoke about, you might have the owner, the prime contractor, a major subcontractor, or two major subs, and the designer kind of take charge of the organizational meetings. And these meetings are utilized to format and schedule and plan the mediation session ahead of time. It's important that these meetings are communicated to everyone. So whoever is going to be part of the mediation needs to be included in the planning process. There is an option to turn the steering committee decisions into a stipulated case management order, which we will discuss as we move forward. I'm going to see if I can take control of the mouse here, which I'm not. Oh, there we go. Okay. These pre-mediation organizational meetings should ideally be face-to-face. I don't really like the telephonic conferences because I think people get a little bit distracted on the telephone because, of course, as we all know, we like to multitask when we're on a telephone conference as opposed to a face-to-face when we can all be together and we have each other's attention. Of course, Skype is a meaningful tool for all this as well. A lot of times there are these multi-party cases where counsel and parties can be scattered all over the state and even across the country. So Skype is a very useful tool in having these organizational meetings. People who are attending each meeting should be the final decision maker with respect to the mediation planning. So it should be lead counsel, should be party rep, and if at all possible, even insurance adjusters. And this meeting should take place at an appropriate site, one that is convenient to the parties. And everybody should make sure that they give enough time for these meetings. These meetings, usually these organizational meetings, are at least a half day, sometimes even a full day in duration. And it's important to have an agenda prepared, written, and distributed to everyone in the lawsuit, not just the committee members. And it should be distributed to have a reasonable and discussion regarding these various issues. And what you start with in these organizational meetings is some housekeeping items. And these housekeeping items are the date of the mediation, where the mediation is going to take place, the location of the mediation, what kinds of facilities are going to be utilized, how many conference rooms will you need, what kind of food is going to be available, and who's going to be responsible for that. You look at the when, where, and overall duration, and all those items at the onset of these organizational meetings. In addition, you might even want to consider whether or not there are going to be co-mediators, because sometimes these cases are so large and you may need to have more than one mediator who can help facilitate the case, especially when the case is in and the parties are in caucus. It certainly helps keep things organized, and everybody feels like they have the mediator's ear if there's more than one mediator with these huge multi-party type cases. In addition to whether or not there's going to be a co-mediator, you also need to decide submissions. You want to limit the size of what's being submitted to the mediator. A lot of times parties agree that there's a packet of information with that everybody will use and refer to, rather than everybody providing a confidential or shared mediation statement, attaching the same documents over and over again or referring to the same documents. So it's important to set that up so we have size limitations and decisions on whether or not submissions to the mediator will be confidential or shared or some combination of both. You have to make sure that there's a adequate mediation participation list. So sometimes during the course of pre-planning, there could be parties that are dismissed or let go, and so these lists have to be up to date, and make sure that that list is up to date up to the time of mediation. And you want to make sure that you have a confirmation of authority issues. You want to make sure that there is insurance authority, corporate authority, and if necessary, governmental authority, which will not hinder the mediation process. And finally, you want to make sure that there's somebody in the committee, in the steering committee, that will be responsible to draft the form of the settlement agreement before the mediation, so that any issues as to whether or not, for instance, there'll be a confidentiality agreement or whatever provisions parties want in the agreement will be agreed upon and in a settlement agreement. So you don't waste time doing these housekeeping issues during the course of mediation. Of course, the mediator will have to send a confirming letter memorializing everything, or we could also look into going into a stipulated case management order with regards to the mediation. If everyone agrees and buys into the process, there shouldn't be a problem getting a stipulated case management order, particularly when a steering committee process is being used. Getting everyone to agree on everything concerning the mediation process, and to have a court approve it or codify it can be very important, because it provides procedural dispute resolution and it reconfirms attendance and authority of the parties. In fact, you might want to get the entire pre-mediation planning process approved with a court order in advance of the planning meetings, if that's possible. If the planning process involve more than one session, or if the mediation itself is likely to involve ongoing sessions requiring ongoing procedural decisions, you might consider generating a stipulated case management order that empowers the steering committee and gives them authority to plan the mediation session and so on, and empowers the mediator as well. It authorizes these organizational meetings. It sets that the order can set the mediation session and timetable, and it can order attendance and authority of the various parties and the individuals who have authority to make the decisions during the course of the mediation. The most critical contribution from the court will be the confirmation of the attendance and the authority requirements. All right, well, I think I might have missed a slide. Do you want to make sure that the entire pre-mediation planning process is organized, and you want to start a game plan? That doesn't mean that everything has to be strictly documented, but you want to be flexible so that at least the parties understand the overall game plan and how the mediation is going to be conducted. You want to start with some preliminary issue refinement and conduct a brief exercise to narrow or consolidate the issues so that you reduce the the scope of the dispute to the center of the case, the core of the case. You want to find out what is needed, whether or not the parties will need to have some additional preliminary discovery, site inspection, document exchanges, expert reports, things of that nature before the mediation commences. And you want to also decide on the mediation format, whether or not there will be opening sessions, which we'll talk about in just a little bit, which I think you must have an opening session, especially for these larger cases, the caucus sessions, and of course, closure. All right. As we set the mediation session game plan, it's important to get a consensus on the goal of the mediation. And of course, most people believe that the goal of the mediation, of course, is to settle the case, but that's not necessarily the definition of a successful mediation. Parties who are in a dispute come to the mediator and have two options. They can either adjudicate or seek a judgment, or reconcile and reach an agreement. And people who own the dispute need to make a good choice between the options that they have for resolving the dispute. And in commercial, complex commercial litigation, they need to make a sound, reasonable business decision, a good choice, whether or not they will adjudicate through, trial or other dispute resolution or reconcile through mediation. The real goal of a civil trial mediation is to get the parties to a point where they have the best data available to make an intelligent, fact-driven choice between their resolution options. The goal is not to push the settlement. The goal is to push information, and this information will generally be quality data so that a decision can be made as to whether to adjudicate or to settle. The best information on the adjudication option, if we adjudicate, there will be a positional debate. There'll be a trial, arbitration, administrative hearing that's staged before a third-party neutral. It'll be a judge, a jury, or an arbitrator in a fault-finding exercise to determine who is right and who is wrong based upon applicable standards. The outcome is an adjudication, a judgment, an award, or a verdict. So what kind of data do we need about the adjudication options will vary from case to case, but it should include the positional debate. What are the opposing contentions of the parties? What are the controlling issues? And what arguments make a difference in the adjudication process? What is the full range of the outcome, the possible outcomes? And what are the consequences of going through the adjudication process? Of course, there's the time, the cost, the diversion from normal business activities, and the impact on future business relationships. So these are all the things that need to be considered, and this is information that should be exchanged in the opening presentations. In reconciliation, there will be a mutual accommodation of interest and concerns, and there will be an agreement that's usually reached through a give and take of positional negotiations. And one important function of the mediation process is to define the reconciliation option. What are the interests and concerns that need to be protected? What are the accommodations, the concessions that can be made to protect those interests and concerns? And what are the possible reconciliation outcomes that would be unavailable if the parties decide to adjudicate? So some of those possibilities are that there could be commercial advantages to reconciliation. And in other words, the parties might be able to find that they can work with each other and get new bids or give each other discounts or have audits or apology letters or things of that nature, where the adjudication process wouldn't afford that kind of creativity to mend the fences, so to speak. The data regarding reconciliation is developed in the caucus sessions. So getting the information out and available is the guiding light, and we must have that guiding light so that we can plan and format and structure the mediation session. More often than not, when the best information is out there, the parties to complex multi-party, multi-issue cases will choose the reconciliation option because there's commercial certainty, there's cost containment, precedent, and time. There's a saying, you don't need to push the settlement, you have to push the information, and then the settlement will follow. You need to develop a mediation settlement game plan as a pathway for understanding the adjudication option, and the adjudication option is really discussed in the opening sessions. We need to develop the reconciliation option, which is the caucus, and the closure on the option that's chosen. And now we're going to discuss some of the opening presentations and why it's such a critical component to the mediation process. The purpose of the opening presentation is to define the adjudication option. And it's critical that decision makers understand what will be involved in a positional debate and not to be convinced, just educated. So the opening presentation should be about understanding what the argument is, not about winning the argument. There shouldn't be any rancor in the opening sessions. It should discuss the time, costs, business consequences, verdict ranges, things of that nature. And again, it's an environment to learn, not to argue. I have been a mediator in many cases where I've heard from counsel that they really don't want an opening presentation because they know what the case is already about. But I'm here to tell you that if you're in a 20 to 30 party case, you don't know what the case is really about. You only know what your case is about, and you don't have a full understanding of what the other parties feel their case is about. So it's important to listen and to have these opening presentations so that you have a full understanding of where these different parties are coming from and why you may be receiving certain offers or demands, and it kind of helps you put those pieces together. I've also heard that opening statements or presentations will alienate the other side, but it's the job of the attorney to advocate and persuade, not to alienate. So it's important that these presentations are factual. Sometimes experts are present during opening presentations, but you have to be careful with that as well, that these experts are not going to be basically banging on the heads of opposing experts, but are simply there to articulate a factual position or a scientific factual position regarding a certain issue. There has been a movement to eliminate opening presentations, but I think that you lose a tremendous amount of information by not having an opening presentation. And I think that for the most part, mediations go a lot smoother and the parties are much more educated when they have these opening sessions. In addition, you obviously after the opening sessions, you have the caucus sessions, and the caucus sessions are really obviously extremely important during the course of the mediation. And in most multi-party, multi-issue cases, the global settlement will be composed of several settlements of discrete parties and issues, and collectively these pieces will make up the whole settlement. Sequencing and bartering process and developing the settlement pieces are critical. So what are the ways to approach these the negotiations, and what will the sequence of activities be? You need to plan and kind of decide how you'd like to have the development of these settlement pieces. And some of these possible negotiation pathways are top down, which you would settle the main claim first and then work downwards. or bottom up, where you would settle the underlying claims first and work up towards the main claim. You can do it through issue groups, for instance, balconies and windows and doors, or the roof, if they can be independently settled, and they not always can be, because sometimes there's overlapping issues. And then there's key issues, such as the cost of the fixed or the nature of the defect. There are other approaches and other sequences for handling multi-party, multi-issue disputes, which might be, for instance, settling the easy ones first, or settling the smaller dollar claims first, or even settling the big players, the heavy dollars first, and hopefully the small dollars will follow after that. And now I'm going to turn it over to Joseph Murphey. He's going to talk about the different approaches.
Great. Thank you, Brenda. I appreciate that. And I would like to join all of my colleagues in thanking all of our attendees for joining us today. So we're at the point now, as Brenda indicated, we need to sequence the development of the settlement pieces. And I'm always reminded conceptually when I look at this aspect of complex mediation. My wife is a big fan of jigsaw puzzles, and there's 1,500, 2,500 pieces, the more the better. And every time she dumps out the box, she doesn't just start throwing pieces together. The first thing she does is decide how is she going to approach this particular puzzle. You know, do you do edges and corners? Does the picture itself have some unique features in it where you can isolate piles of pieces and go about it? And it's a combination of what you know has worked before and a combination of what's the picture you're trying to assemble in this particular instance. So taking that approach, we've got four basic ways you may want to look at sequencing these pieces in terms of the actual execution of the mediation. We're going to go over each of these in basically its purest form, and then talk about how we might apply these in a particular situation. As we go through them, you'll see each has advantages and disadvantages, and more often than not, you're going to end up doing some combination of these styles, or maybe, as Brenda indicated, some other approach. Start with something easy, that kind of thing. But as we look at just the different things we have here, the top-down path slide that you've got right now, we've got our main players here. We've got slick deal versus no wrong claim, the cross claims and third-party claims. We've got over here the deal with the designer, and maybe we start here at the top with these major players and try to confront those issues first. Resolution of this is where we're going to have to end up, so maybe we start there. What are these main issues and claims that are going to have to be resolved? Upsides to doing the top-down path, one big one might be preserving continuing relationships between these parties. If this is a developer that deals frequently with this, let's see, okay, if we have a developer that's dealing frequently with this particular prime contractor, there's ongoing relationships or ongoing work in this current deal, we may have a need to get in quickly and patch these things up, try to get some resolutions going with the main players here that are more essential for that purpose. Time constraints may also be an issue. Again, if there's warranty issues or other issues where a clock is ticking and we really need the big parts of this to move quicker versus getting the dirt and the cladding and other issues taken care of, there are upsides to using the top-down method. One obvious drawback to top-down would be if you're spending a great deal of time initially in the mediation with your main players, you've got a lot of people waiting in the wings, these third and fourth party players, waiting on the sidelines, cooling their heels, not really participating. You walk into their room after some extraordinary delay of time and say, this is the deal we've got, here's what you've got to do. It's not necessarily going to be well received. Also, too, very often in these situations, the money that's going to fund what the prime can do to satisfy the owner is unknown until we work with some of these lower players to find out what funds are available through insurance or other sources, what deals can be struck below. It's a bit of a pig in a poke for the for the prime contractor to strike a deal, not really knowing where the money's going to come from, and also too, as I mentioned before, these folks at the bottom and at the fringes are not bound by any agreements that are made at the top. So to walk into somebody's room after a great delay and tell them this is what you got, this is what you got to deal with, is probably not going to work that great. And let me see if I can. Trying to move to the next slide here. And, I wonder if I can get some assistance moving to that next slide. Okay, so bottom-up path would be there we are. Bottom-up path would be the opposite, where we say, let's start with these third and fourth party claimants or defendants. Let's reach down to them and find out what kind of resources we can put together that can potentially put energy into the deal above. It's also an opportunity to kind of structure types of deals. If you're dealing with someone who's a third or fourth party player down here, you might give them a deal. We could call that a Cadillac deal, where you pay X amount of dollars and you're done. Whatever I can, the prime might say, whatever I can do with the owner developer, if you pay me this, it'll be my problem after that. Another deal could be, okay, if this is all you can pay, you might call that the Ford deal or the Chevy deal. If this is all you can pay, if I can get it done for that, then you're good. But I may have to circle back and hit you up for some more contribution if we cannot execute certain deals. So it gives you an opportunity to kind of work in a continuum style fashion with those lower level players. It's also an approach that tends to lead more towards a global resolution. If you're working in the center, making deals, and the people on the outskirts are less involved in that versus working outside toward the middle, you're sort of working towards a final resolution that ends with the main players. What are the downsides? Well, the downsides of the bottom-up path are almost corollaries to the downsides of the top-down path. Now, who's waiting? Well, the main players, your owner and your prime contractor, are now cooling their heels, waiting for other things to happen in other rooms. And also, it's the same problem in reverse. You can gather all of your money and resources and funding and make your conditional or whatever deals you can make down here below with your third and fourth tier players, and that pile of resources or funds that you pull together may not be enough to fund what the prime needs to then close the deal with the developer. So you have that same sort of working in a vacuum and not knowing if what you're doing is going to translate up the line in this case versus down the line. In our example here, you can see on the bottom-up path, we've got no wrong settling with all of the cladding contractors, HVAC, and others down there, and trying to pull those resources and move them back up the line. I almost think in a situation like this, though, when we're talking about people sitting on the sidelines for extended periods of time, and we're trending now towards a blend of these two styles. One of my first jobs was as a waiter in a busy restaurant, and I always found the biggest challenge was not just the number of tables that I had to take care of, but the differences in the needs of those tables. You would have one table of a large group celebrating a special occasion. You'd have a table with a couple over here having a romantic dinner, and then you've got 4 tables of families with small children. Everybody's in there for the same purpose. They want a great meal, a good experience, and they want to get out of there in timely fashion. But meeting the needs of those folks are very different, and you have to do a little triage. Who's more important, and making touches at each table and with each person, and making sure that everybody's kept in the loop and gets what they need is an essential skill of both a mediator and a waiter. So it sounds like I had good training for that. Let's talk about a couple of other ways that this can work And again, none of these is probably going to be used in its purest form. Brenda mentioned the issue group path. This is the concept that if we've got freestanding issues that can be isolated, then we maybe can, and this is also where you may want to integrate the use of a co-mediator or a couple of co-mediators who can go off. And in the example we've got here, no wrong versus easy. You got the whole cladding group over here. Why did the bad stucco fall off of the structures? Well, that's an issue that's independent and separate from maybe the dirt issue and why the drainage isn't working. So we could have people working independently on those. There's no overlap between these. There's no necessary correlation that we have to have between these concepts. I will say that you need to be careful as a mediator that you don't have things that look like independent issues but really aren't. And a personal experience of mine comes to mind in mediating a case that involved a 4-story structure. The essential case that was brought by the owner of the building was there was a really bad mold infestation or mold problem in the main floors of the building. There had been a roof leak, and there was a group of contractors involved with the installation of the roof. There had also been a sewage backup leak in the basement, and there was a group of contractors involved with the basement leak. Absolutely no correlation between the cause of these problems. They could be independently worked on in terms of who in the roof group is responsible for the roof problem, who in the basement group is responsible for the sewage problem. The challenge, though, was the real issue was what caused the mold. And that was where the real dispute was. Both the roof people and the basement people agreed it was an 80-20 split. They just didn't agree who had the 80 and who had the 20. So the real thing there was to resolve where did the problem come from? More from the roof, more from the basement. And I'm kind of sliding now into my next slide of the key issue slide. But once we unlocked, and not surprisingly, as is often the case, both sides in that dispute grudgingly accepted a 50% position, both thinking that they were overpaying, and then we could turn to the separate resolution among those contractors who screwed up the roof, who screwed up the basement. But again, the key there is if you're going to go issue, it has to be an issue that is something that's standalone, independent, and doesn't rely on pulling some other group into it. And again, I've segued already to the key issue path. What is a key issue is essentially a logjam type thing. It's basically saying, is there one thing that's sort of a Jenga block that we can pull and it brings everything else down in terms of, it's like the issue path, but it's like finding that one thing that might either loosen up all the other issues, or which is, if everything else is agreed on, is still, if this one thing isn't resolved, why are we here? If there's a bond that there's a question about, what's going to happen with that? If we can resolve that bond issue, know we have funding into this, insurance coverage issues. If you've got a single purpose entity that is basically, or single asset entity that is involved in here, and there's only the bond or the insurance coverage that's going to be of any use in getting any of these other issues done, we got to find out if there's money to do this before we can wage the war. In feudal times, before the king would war with a neighboring monarch, they would send the lords and the knights and the vassals out into the kingdom, raise an army, tax the people, and once we find out how much we've got together, then we can find out what kind of fight we can have. So it's basically finding that key thing that might be the most important thing. And looking at each of these 4 ways of approaching the dispute, question arises, well, whose responsibility is it to decide which or what combination of these ways of looking at assembling these puzzle pieces is going to prevail? I believe as a mediator, it's the responsibility of the mediator to take the helm of that discussion. As a mediator, I also believe what we're really doing is empowering people to make their own decisions. So if the players and the parties do not have buy-in on making this decision, a mediator who says, here's where we're going to start, here's where we're going to go next, and here's where we're going to finish, is just a dictator. And that's not effective, and it's not the right way to do it. So we know as mediators how to guide people to make suggestions, always letting them know they're empowered to make decisions. But here's a pathway. I find that people do like to make choices, but they like to be presented with concrete choices. And the mediator's job in this aspect of just planning how to attack the problem is no different than it is in other aspects when we're trying to guide people to doing the right kind of decision making. Let's quickly run through how it might look as applied in a certain situation. And what we've decided in this situation is we're going to have a 3-day mediation. And the type of approach we're going to take in terms of how do we assemble these puzzle pieces and how do we structure our agenda for these 3 days, we're going to do a blend of top-down, bottom-up. And we're going to start on our day one, and we're going to do openings on the main claim. This is where the owner is going to make the owner's presentations. Again, as we're planning for the actual physical event of this happening, we need to put time limits on how long is each side going to make a presentation, what equipment is going to be necessary, are we going to allow experts to make a presentation. We want to have a level playing field here. We don't want one side showing up thinking this is going to be a lawyer presentation and the other side showing up with a cadre of experts and somebody feeling like they really got one up on just the procedure and how the presentation goes. So we have our presentation by our main players, and there will be the defense presentation that's made by the prime contractor here, maybe the designer as well, would be one that sort of gives a good summary of the common defenses. There's going to be things that all the defendants agree on, whether it's the owner really caused all these problems because they insisted constantly on changes that kept us constantly off course of the original plan. Or, we did this thing right, but the maintenance on this structure was not properly dealt with, and for that reason, that's why there's problems. What common defense issues there are, we're not going to get down into the nitty-gritty of the fourth party defendant's defenses to the third party claimant on some point of minutia, where we're taking more of a 10,000-foot view of what's the main dispute, what's the main defenses. This process should probably end at sort of around middle of the first day. It should also end with the owner giving some rebuttal to what's been presented by the prime defendants and a demand, if it's not already out there, to be published to the prime and all the other sub-defendants, with the owner then retiring and giving in the balance of that first day an opportunity for a real hair-down discussion between the prime and the subs. There's not a lot of dirty laundry at all that needs to be aired in the initial opening. The defense is probably going to present more of their common points, but once the owner leaves and with the balance of day one, what we're going to do there is turning now more towards our dealing with down the line defendants. What are the individual complaints and responses that these third, fourth party defendants, fifth party defendants have up the line, and how does the prime respond to those? One good exercise I think to do at that point in time is to sort of quiz or test all of the defendants about what they think about the main claim of the owner. There's not going to be a lot of excitement to get together to fund a $25 million claim when the defendants collectively think there's $5 million worth of damages. So whether you do it by written ballot and then submitted privately and announced to the group, and some way or another, try to find out what collectively, regardless of who's responsible and who has to end up trying to satisfy the owner, regardless of how we collect that money, what do we think about that claim? Is it a good claim that I just don't think I'm responsible for? Is it a partially good claim? What is the value of that claim itself before we start to split up who's responsible for it? Discussions of the first offer may also occur towards the end of day one. Maybe I found that in initial offers, if there's a real argument about percentages of fault over a particular item of damages, sometimes you can get folks to go pro rata. It's not unlikely an owner's going to take a first offer. Maybe we can split 80, 20, 75, 25 later, but for now, can we all go 50-50 to get some money on the board and get things moving? it gets us in the habit of all putting together and working together. So that's a way, if the facts to that, you may want to do that. So that is our day one. Let's see here. Catching up with my slides. If I can, let's see. I'm having trouble moving my slide again. For some reason. Okay, so we've got the second part of day one, which we already talked about, and owner absent part of day one, we've already chatted about that. Let's see, I'm just having slide trouble. Okay. All right. Trying to get to the beginning of day two. Well, I will start. If anyone can help me get that slide over to day two with the first caucus session. So what we're going to do by day, already begun some of this at the end of day one, is we're going to start those caucus sessions between, in this particular way we're going to set it up. We're going to have the prime contractor in what we'll call headquarters or a main room, and subs all in the breakout rooms. And then the subs can come periodically in and out, back and forth with the prime contractor to deal with their particular little issues. And again, being the waiter and working our tables, we're going to try to keep everybody apprised of what's going on. The people that are there busy. At this point in time, if the owner's not involved, maybe they don't attend that day. We don't have them, just cooling their heels. Couple of protocol notes about dealing in this first caucus session where you've got a lot of folks running in and out, a lot of information coming in and out. It's very critical that you keep very good notes and records of offers and demands and other things that are going on. A really great way to do this is to put marker boards in the headquarters room, put them in all of the breakout rooms. As you're going in and out of the rooms, get these things written down from the mediator's perspective. Repeat back offers and demands. Make sure you clearly understand offers and demands. If you're in a room that has multiple players with different interests, don't let the person who's the most loquacious in the room be the one who kind of commands the conversation. It really needs to be, you're clear of what's going on and you're clear of documenting what's going on. I'm going to get on through this because we're a little pushed for time here. Let's move now to day three. Let's say during day two, we've gotten through the bottom up and top down work that we've done. We're now, we have things to present to the prime. And there's two things that should have been developed through our day two efforts that we're now taking back to the owner and saying, here's what we got. Thing number one is the money from the subs. Whatever we've gathered and garnered, who's accepted responsibility and what money from the subs and the designer group, we've got that money. The prime is also going to have some money probably to put with the money that's been gathered for the prime's share of accepting of responsibility. So you got your money, your pile of money. The other thing you've got is your data. In the process of dealing with all of these various defendants and claimants, you have a vast cadre of things that have been said in defense of the owner's claim. This is also in use as you're presenting the money, present the arguments. So what we come to next, once we've presented to the owner all of the benefits of everything we've done downline, and we're now back to that central dispute, we're at day three. And at the end of day three, perhaps we've got complete closure, perhaps we've got partial closure. I don't have a great deal of time to talk about it, but during the process of wrapping up, we may be talking partial deals or cutout deals, carve-out deals. Sometimes discussing carve-out deals can force others who are outside of those deals to want to come back in. Fear of missing out. FOMO can switch you back to globe. But let's just say you've got to day three. You've got this fragile flower situation where tensions are high, stress is high, everyone's nerves are frazzled. We're trying to get these agreements set, and fortunately, you've already done if you've followed Larry's instructions earlier, you've already gotten to the point where you know everything but the blanks as to what the terms of the settlement deal is going to be. So I'm going to hand it over to John at this point to talk about what we do in day 3 if we're drafting a final agreement or carve-out agreements. Obviously, we're going to be planning for future discussions, but John will take us to the end here, talking about what to do with future issues downstream from day 3.
Well, thank you, Joe, and Brenda. Thank Larry. We're all kind of riding along on a presentation that Larry provided and did an excellent job putting together. So those of us at Miles very much appreciate that. One of the things that I've done early in my career, I did a lot of mediating, a lot of construction mediating, but my role now is kind of running the organization, and part of that is training and charting numbers, analytics, and so forth. And one of the things that we've found at Miles, if you're dealing with one of our seniors like Joe, who does a lot of this kind of work, you really have a pretty high percentage of resolution on the date, like at day 3 or whenever it concludes. Joe runs somewhere 85% plus of getting those things resolved. But there are occasions where the case doesn't resolve. And one of the things I preach at Miles to our neutrals when we do our trainings is provide value, provide value, provide value. So if it is in one of those cases and you're going to be billing folks for this time, you want to make sure that you don't leave them worse off than when they got there. So think through the downstream steps. Think through things that you can do to get this thing back on course, or at least to have folks leaving feeling that they've gotten value. So first of all, define why the case won't settle. I've had this happen. I know Joe has too. You might bring the folks back together, a summation of, so everyone understands where everyone is coming from. Then what additional information? Now, not in the construction arena, but in the personal injury arena, if there's an additional deposition that might need to be taken, an expert that might need to be talked to. I have gotten cases where I get the folks to say, now we agree that if the expert says X, then we're playing on the plaintiff's side of the field. If we get the expert to say Y, perhaps we're on the defendant's side of the field. But kind of get that agreement, and then go ahead and gather that information. I love the idea that when I first looked at this, I think there's been a lot of things in this presentation that have been quite good. I really like point 3 there. Define how cooperatively you can get the information, so we don't have to spend a lot more money. I know that Joe recently did a mediation where he actually was able to get an expert on the phone, and they were able to get him on the phone. The parties came in and formally talked to him. Mediation that was about to go way off the rails. All of a sudden, after a 20-minute phone call, it's back on track, and they were actually able to get it done that day, but that could also happen later. And then developing data, setting a time to reconvene, or maybe more accurately stated, what are the parameters or what is the information that we would need to gather so that reconvening would make sense. And looks like I'm having the same problem with getting that slide. If we could move to the next slide, thank you. Cooperative focus discovery kind of picks up on what we were talking about earlier with people cooperating, especially in these construction cases, audits, tests, things that will provide clarity, very good idea to grab those. And then this is another great idea that Larry showed that I hadn't really thought through, but getting the court involved with case management, discovery orders. Believe me, in a case with the multi-parties that's going to take up 1 to 2 weeks of a court's time, they are going to be interested in giving whatever information they have to give, providing whatever clarity or direction they have to give to help the parties reach resolution. And then the next slide. So to conclude, these multi-party, multi-issue mediations, you got to have the organization. You have to have a neutral being active in getting the parties on the same page and getting them to agree to how you're going to proceed. Of course, that requires contact with them. The planning and preparation, as Larry so eloquently stated, is so important. Making sure you manage your time, as I'm trying to here, and then develop a game plan, but stay flexible. I mean, being a neutral is so much about that. I tell my guys all the time, it's a lot more art than it is science. And then persistence pays off. And one of the things I think that marks good neutrals, as you've heard from Joe Murphey on our team, is he just never gives up. He just takes it personally if a case will not resolve, and he's going to be, hammering that thing, kicking the tires until someone or all of them tell him to stop. So with that, I will turn it back to Kathy, who I think was going to give some information about CLE.
Thank you, Mr. Miles, and thanks to all the presenters. That was great. I wanted to let everybody know that we're going to co-present additional webinars September 18th. That one will be on elegant arbitration, designing cost-effective and timely arbitration proceedings, and December 11th, mediated negotiations, tips, techniques, and the language of professionalism. And you should watch your email inbox for news about our future programs. And now here's the thing everyone was waiting for, the CLE information. And it is that we are accredited for at least one CLE hour in all 3 of the states. If you are a Florida attorney, please jot down the Florida Bar course number so that you can post your CLE credit online. It is 190409-1N, as in Nancy. Again, that is 190409-1N, as in Nancy. If you are an Alabama attorney, we'll report your attendance to the MCLE Commission based on the information you give us in a follow-up survey. For those in Georgia, Miles Mediation will follow up with you to obtain your bar number, and they're generously covering the CLE cost. Again, thank you for joining us today. And I'm going to finish up with some contact information. Please email Larry Watson, lwatson@uww-adr.com. Brenda Newman, bnewman @uww-adr.com. John Miles, jmiles@milesmediation.com. Joe Murphy, jmurphy@milesmediation.com if you have questions or comments about the content. And contact me, that's cklasny, cklasne, @uww-adr.com with questions about the course number, webinar recording, etc. Thank you from Upchurch Watson White Max Mediation Group and Miles Mediation and Arbitration.